Order! Order! You are an incorrigible delinquent at times. Behave yourself, man!
The government's so-called Snoopers charter is to be watered down after the European Court of Justice ruled parts of it are illegal. Judges in Luxembourg say communications data, like emails, phone records, can only be accessed by the government to fight serious crime. At the moment, powers are much broader, allowing the bulk interception and retention of data for up to a year. Jane Dodge has this report.
Big Brother may be watching and listening, but government surveillance has gone too far, according to the European Court of Justice. It says parts of the so-called Snoopers Charter are unlawful, particularly the retention of all internet and phone data for a year. Civil liberties groups have welcomed the ruling.
We think it helps us a great deal. If what is a relatively minor intrusion on privacy, the retention of communications data by communications companies is found to be inadequately protected by safeguards, the same principles must apply to other powers in the Act which are far more intrusive. Powers of the government to, or the security services to get communications data in bulk, powers to hack people's computers, powers to access email communications.
It's highly embarrassing for the Prime Minister. As Home Secretary, she oversaw the introduction of the Data Retention and Investigatory Powers Act. And it was her very own Brexit Secretary, David Davis, who as a backbencher instigated the legal challenge back in 2014, along with Labour's Deputy Leader Tom Watson.
It's more intrusive than, I don't know, the Stasi had. So it's not right for a free society to allow that.
Brexit may mean less EU intervention in British politics, but not quite yet. The European Court of Justice has ruled that general and indiscriminate retention of data must stop. It says it can only be justified in cases of serious crime and must be authorised by an independent authority, like a judge, and not a senior police officer. A Home Office spokesperson said they were disappointed with the judgment. They added, "We will ensure that plans are in place so police and other public authorities can continue to acquire such data in a way that is consistent with EU law and our obligation to protect the public." As extra security measures were introduced at Buckingham Palace, intelligence agencies expressed their concerns that today's court ruling could hamper anti-terrorist policing.
If it's interpreted in a sensible way, then it's good news because it's a further strengthening of the safeguards. If, on the other hand, this ends up tying the police in knots and delaying the arrival of information on which cases like kidnapping could depend, then it would be a very bad day.
So will the government have to rein in its surveillance? The Court of Appeal will decide how to apply the European ruling in the new year.
Jane Dodge. With me in the studio to discuss today's ruling is Jim Killock, Director of the Open Rights Group, one of the organisations which brought the case against the government. The Home Office was unable to make anyone available to speak to us, but pointed us instead to the expertise of Professor Anthony Glees. He's Director of the Centre for Security and Intelligence Studies at the University of Buckingham. He joins us from Woodstock in Oxfordshire, and presumably you can voice the government's anxiety about what's happened today.
Well, I'm not sure the government is as anxious as people might think. The government will appeal. They'll also try to ensure that the latest raft of legislation, passed only a few days ago, becomes compatible with the sorts of things that the European Court of Justice has ruled on. However, it's very important to note that the Lisbon Treaty, which governs our relations within the European Union, and we still are within the European Union, specifically says that national security is absolutely not a European Union matter. In other words, the fight against terrorism and the use of interception against terrorism to a large degree, and we're very good at it in the United Kingdom, as we've just heard. They're fairly bad at it in the Federal Republic of Germany. That will go on. That won't be affected. What this is about, though, and I think this is the more difficult area, is the politics of interception. What is acceptable?
Well,
and
let's pause you there. Let's pause you there, because that's what our other guest is fairly hot on, I suspect, which is, in the end, a human rights issue.
Yes, I mean, this is about the retention of a lot of data, the access of that data by 40-odd authorities in the UK. All of the access of that data happens without external authorization at the moment. So it's a police officer authorizing another police officer. The people whose data is accessed are not notified, they're not told about it. And of course, it's retained for a year in a blanket fashion. So everybody's data, your data, my data, everybody who's viewing this, their data is kept, along with now internet connection records, so the history of what you read on the internet. Of course, that is chilling. We know, for instance, on Wikipedia, people are no longer visiting pages about extremism to learn about that because they're under fear that they're being watched.
Well, Professor Glees does say that the effect of this case today is that they will have been more cautious about drafting the new legislation.
Well, what's surprising about this is we've just had a new bill. We've got this Investigatory Powers Act. This judgment has merely reiterated what the European Court said 2 years ago. It said you have to put safeguards, you must have independent authorization. The government just ignored it, and that's quite shocking.
Professor Glees, I mean, was there nothing about what the government has done that gave you some slight sense of queasiness?
There is nothing that the government has done in the latest legislation. It's all a bit complicated, the legalities.
About this case.
No, well, I think what the government will try to do is to meet the objections raised by the European Court of Justice in Luxembourg. It will try to define more closely those areas where bulk retention, that's really what we're talking about. We're talking about the bulk retention of communications data, not the contents, but the name, address, and so forth. That's what we're talking about. Now, the argument that we hear from the civil liberties lobby is that this affects everybody. I mean, David Davis, who's now in the government, of course, went to the European Court of Justice in the first place with Tom Watson and said it's as if the whole of Britain was under suspicion. That is total nonsense. What's more, by retaining data, and all the government is saying it should be retained for a year, which isn't very much, you can exonerate people. I mean, think of the role that DNA has played in getting people off the odious death rows of the United States of America.
Okay, well, let me pause you there.
Let me pause you there
and put these points to Jim Killock. I mean, Jim Killock, for example, if in fact this act had been used to sweep up some of the best of the tax evaders in this country, you'd be thrilled.
Well, I think, there's a right to investigate people who are under suspicion. That, of course, should happen.
I think I've caught you there. You seem to be slightly hesitant.
No, look.
I mean, surely one of the worst crimes that can be committed against a society is tax evasion and avoidance.
Do we want everybody... last week, a journalist was revealed to have had his data accessed by a police officer who was upset that he was investigating his fraudulent trips with his girlfriend to the States. And that's the kind of abuse you get when you've got blanket retention and no serious authorization system. Journalists have been one of the biggest targets here, and that doesn't just affect the odd person, that's the whole society's free speech undermined.
OK, I mean, free speech is obviously a big issue, but I mean, would you take my point on tax evasion? Would you be excited to have what was used today, Professor Glees, in the court case that was heard today? Would you be happy to see it used against tax evaders?
Of course. I mean, I think it is very important that people, the civil liberties lobby, led by David Davis, I should say, should stop trying to place privacy above security and the well-being of society as a whole. Privacy is important, but security and the well-being of society is an absolute. It's only by mining data. The way the intelligence community do this is the way we all do it when we use Google. They're not after everybody, they're after particular targets, and they need this data in order to discover networks. That's what the Germans did clearly not do in the case of Berlin. That's why they're running around in great confusion. They don't do it. They could do it. They don't do it.
Professor Cleese, thank you very much. Jim Killick, I'm sorry, but we've run out there, but thank you very much.
I'd just say,
yeah, quick.
think about Le Pen having access to this stuff. Think about all the far-right organisations having access to these powers. That's the real threat that we need to deal with.
Let us leave the viewer thinking.
John.